Welcome, it's Jen, the Liberty Lion, and today we're going to talk about tender and legal tender. And so really I'm just going to go over some definitions with you. So tender, the way I understand it in its very most simplest term, is a contract. So tender basically is a paper contract. Legal tender is when a paper contract has been legalized for use, maybe for other purposes besides just paying debt, but from what I've seen in these dictionaries, it's mainly legalized as a method of paying debt. So it's a paper contract legalized for the use of paying debt, which I'm not sure why they don't just go ahead and use gold and silver. Anyway, since gold and silver can be used to pay debt. Well, I think gold and silver can be used to pay debt. Gold and silver comes from the earth, and they say that debt is something man-made. So are we using something natural that comes from earth, something true, to pay something that maybe doesn't really exist because it's man-made? Some philosophers, some law philosophers, say that man-made things are fictions. There's a lot written about this concept, that anything man-made is a fiction. Now, fictions, it doesn't mean that fictions aren't real, but fictions aren't true. And so we have the law, capital T, capital L, which is the natural law, and then we have lowercase t for the, lowercase l for law, which is not the law, but it's man's law. It's not the law, natural law, but it's man's law. It's the fiction. It's the copy. If you think about the ship of Theseus, and my previous videos, I've mentioned it once, and I've told the entire story of the ship of Theseus and how the ship of Theseus was a ship that set sail, and as it was sailing, it was decaying. As it decayed, the captain and the crew would take a plank off and throw it overboard and put a new plank on and replace it. Behind the original ship of Theseus was another ship, and it was picking up all the old planks. As it picked up the old planks, it was using them to rebuild its ship. So then you have the original ship of Theseus being capital T for the Theseus, capital T for Theseus. And then you had the second ship that was built from the old planks called lowercase the, lowercase t. Lowercase t for the, lowercase t for Theseus. So you had the original ship of Theseus, and then you had the second ship built from the planks. And it was a thought experiment. So the experiment then asked, which is the original ship? So if you look in the Articles of Confederation, you see capital the United States of America. But in the Constitution, you have a lowercase t, the United States of America. So which is the original and which is the copy? So when we're talking about legal tender, we're talking about something that looks like money, but isn't really money. It's a contract. It's a paper contract. It's sort of a symbol used to represent something else. But that something else can't be used, such as gold and silver, to pay debt, because debt is a contract. A contract is man-made. All contracts are man-made things. They're not, you don't find contracts in nature. So how do we use gold and silver, a real thing, to pay for a fake thing? And that's sort of the basic rundown or my understanding of the philosophical arguments about law and what is tender and what's legal tender and what is the law and what is lowercase the law, so on and so forth. So here I have Bouvier's, I don't know how you say, Bouvier's Law Revised 6th edition. Tender. Contracts. Pleadings. A tender is an offer to do or perform an act which the party offering is bound to perform to the party to whom the offer is made. Okay, so the exchange of a piece of paper to pay a debt. Because they took us off the gold standard, the paper doesn't represent anything real. So then you have to say, well, then the debt doesn't represent anything real. So the debt is not real, and what we're using to pay it off is not real. I mean, just using some basic logic. I'm not saying I'm right about this. I'm just trying to make sense of it. A tender may be of money or of specific articles. See, your paper contract that you receive is for doing work, right? It's a wage. But here's the thing. Your labor, your work, your labor, your human equity, human capital is a natural thing. That's why you accept gold and silver for it, because gold and silver is then a natural thing. And then you go and you spend that on other things. But when you receive a piece of paper not backed by gold and silver, you're getting basically nothing, or a fiction, for your labor, which is real. Anciently, labor represented wealth, and you did things with your labor. So you accumulated land, a home, animals, so on and so forth, with your labor. Your labor was your property. Your property was what you had based on something real, which was your labor. Your labor is real. It's natural. For someone to give you a piece of paper backed by nothing for something real, which is your labor, it looks like they're stealing your property, and your property is your wealth. So they're giving you these pieces of paper that are valueless. Their only value is the fact that we take it and we use it, and we use it to buy things. It's not really wealth, and it's not really representative of something real, let alone the fact that it's not based on something real, or something true, I should say, because gold and silver is true. Contracts and paper money and fiat currency is real in that you can feel it, you can see it, because it's all based on your senses. But it's not true money. It doesn't have true value. Okay, and this is the wording and the way I understand some of the philosophers who explain this stuff. Again, it goes back to the philosophy of law. Okay, so that's Bouvier's, and that's let's see, I don't know what year this is. Let's look at the year real quick. Oh, I don't have the year for this one. This is, I think, a fairly recent. The 6th edition is fairly recent. So this is 1979 Black's Law Dictionary. So back in 1979, money was taken off the gold standard. It had already been taken off the gold standard. It was taken off in, like, I don't know, 70 or 71, something like that. So let's see what Black's is used in all the law libraries. And they have the American jurisprudence, and they have the state jurisprudence books in those libraries that reference Black's. So tender, an offer of money. So when we say an offer of money, we're talking about something that has value. The act by which one produces and offers to a person holding a claim or demand against him the amount of money which he considers and admits to be true. So a debt, a paper contract. So it's an offer of money to the satisfaction of the paper contract, the stipulation, any stipulation or condition. So if you were listening to my videos, taxes are paid for by their paper money, and taxation is a contract with stipulations in it. A license is a contract with stipulations in it. Insurance is a contract with stipulations in it. Paper money is a contract with stipulations in it. For example, I cannot sell raw milk using paper contracts because there's a stipulation in the law that says that I can't do that when I'm using paper contracts. But I can sell something real for something real. So I can sell raw milk for gold and silver because they can't put gold and silver in a paper contract because a contract is a fiction and gold and silver is true. Okay, so if you want to download Black's Law Dictionary, 5th edition, it's easy to find online. They're all over the place. I usually get my books from archive.org. Let's look at 1891, A Dictionary of Law, Henry C. Black. Let's look at tender. Again, it's a paper contract. 1891, an offer of money, the act by which one produces and offers to a person holding a claim or demand against him the amount of money which he considers and admits to be due in satisfaction of such claim or demand without any stipulation or condition. Tender in pleading is a plea by defendant. Your papers that you put in court are tender. Legal tender. Money is said to be legal tender. Now, I've been saying for a while now, legal is fiction because it's man-made. It's outside of the realm of nature and natural law and the law. Okay, it's real, but it's not true. Legal, a fiction, man-made fiction. Now we can agree to man-made fictions. We can agree to them. We can agree to any man-made fiction that we want. Customs are a man-made fiction. But when you have legal things that go far outside of the natural world, then you have the right to say, no, that's too far. And it becomes so far outside of the natural world that it's then unlawful. So it's legal, but it's an unlawful legal thing. So it's so far away from nature, it's as if you're being compelled to do something that's impossible. And laws basically really have to be agreed to by the whole of society. And when they're not considered law because they're no good. And law cannot compel a man to do something that's impossible. So to trade our real labor, our property, our wealth, our children's wealth, for a piece of paper that has no value or is valued at according to something that is not real, is man-made, may be legal, but it has no value. We're trading something that has value for something that has no value. Okay? And that's an impossibility. You cannot be expected to do that. Or a negative value. Maybe there's a negative value to it. You lose. So you work and work and work and you continually lose. How many people feel like that's the case today? You're continually losing in the system, no matter how hard you work. So this is 1889, Anderson's Dictionary of Law. And again, I just find these online, usually at archive.org. And this is a really long definition. So I don't really want to go over the whole thing. So you can go and find these dictionaries online and you can read them. and just pay attention to the words and what they mean. Tender, when either side traverses or denies the facts pleaded by his antagonist, he is said to tender an issue. Okay, so when you enter your court papers and you're arguing, you're tendering an issue. It's a paper tender. It's a paper. It's paper. It's a contract that you put in court on paper, or an argument, or a situation, a situ. That the law is according to the situs, which is where it sits. Okay, and I've done a few videos on situs and situ and situation and the relationship of the words. So if you want to know more about that, you can go check out one of those videos. A formal offer, a proffer, which binds him who refuses it. Okay, says may be by proffered delivery of a thing, of services, of an obligation. An obligation is what's part of what's written in a contract. Most commonly is money actually produced unless the creditor has dispensed with such production. Imports not merely readiness and ability to pay money or to deliver a deed or other property or thing. Now again, this is in 1889. So our money back in 1889 was still backed by something real, gold and silver. It wasn't taken off the gold standard until I believe it was the 1970s. So here, when it uses money, it's talking about something real. As far as what I understand to be the truth, it's talking about something real, but it's still the paper money is still the symbol of something real, but it's a symbol of something that's actually true, which is the gold and silver, because the paper represented the gold and silver. Later, they took us off the gold standard, and then the paper did not represent anything real. Legal tender, an offer to do a thing conformably to the requirements of the law in the case. So when you go to court and you agree to something and you agree to do it, you're agreeing to the requirements of the law in the case. So according to whatever agreement you come up with, or when you make a contract. So when an insurance company says, we will, or a doctor says, we will accept this insurance, they're accepting the stipulations of the contract. Okay, and they're going to work within that contract. That's why some doctors take some insurance and some doctors don't, because they don't agree with the stipulations in that contract. So if your doctor takes your insurance, it's because he works with that insurance company, he knows what the stipulations are, and he agrees to work within the stipulations of that contract. When a doctor gets a license in a state, he's agreeing to work within the stipulations of the contract that he has to follow in order to retain, maintain, obtain his license. Okay, when you get a driver's license, you're agreeing to follow all the rules and regulations that they put forth for people who obtain a license. So you get the license, when you sign your name, you're agreeing to all those things, all those stipulations in that contract. It's the same when you purchase a vehicle and you sign on the line. You're agreeing to all the stipulations in the contract. If you don't pay for the vehicle, if you don't make the payments after so many missed payments, they come and pick up the vehicle. It's the same thing for any license, any contract. It has stipulations in it and it becomes legal tender. The dollar is no different. And especially now that it's not backed by anything true, it's worthless. And so you're compelled to do something that's impossible, which is basically give your money or your wealth, your labor, which is your property, which is your posterity, because your children would inherit that, you're giving it away for nothing, for debt, for a paper that's valueless because it is not backed by gold and silver. Okay, legal tender acts. Congress authorized the issue of notes of the United States, declaring them a legal tender for all debts except duties on imports and interest on the public debt. So this is what I want to say here in this next part. I don't agree with the next part that I'm going to read to you. Okay, and the reason why is because even though in this part they say that it's constitutional, I'm going to tell you that it's not constitutional because the federal government was never given the right to wage war on its own citizens, on its own people. Okay, they were there to serve the people. So that's why the maxim that I've been talking about, which is the servant cannot become the master and the tenant cannot become the landlord, that's why those things are so important here, because the United States is the servant of the people, and the United States, being the servant, cannot wage war on its master, the people, and it did. It did during the Civil War. The United States is a tenant on the lands of the independent states, and they made themselves the landlords by declaring, when Lincoln declared the states rebel states, said that they were illegal states, took them over by military force, and that supposedly legalized them. And this is why that's a big argument in those other videos that I made on state and the legal state and illegal state. And so I uploaded a few of those the other day. If you didn't catch those and you want to know more, go and watch them. So I don't agree with this next section where they say it's constitutional because Congress has the right to make war, and they basically made war on the people. So the legal tender acts chosen as a means to a proper end, suppress rebellion and preserve the government, were constitutional as appropriate and within the power of Congress to declare war. The clause to coin money contains no implication that nothing but the precious metals can ever have the uses of money. The acts apply equally to pre-existing debts and to debts contracted subsequently to their passage. Okay, so again, this is Anderson's 1889. Some people call him Stinkin' Lincoln, and I agree. Okay, you can just find these online, archive.org. So this is 1851, so we're going back in time. Burrell, Volume 2, A New Law Dictionary and Glossary. Tender, an offer of a sum of money in satisfaction of a debt or claim, by producing and showing the amount to the creditor or party claiming and expressing verbally a willingness to pay it. A mere offer to pay is not, in legal strictness, a tender. Okay, remember Amber Heard said, well, she pledged and she donated, but that's not the same as paying, right? That's what it's saying here, because she never paid the full amount. A mere offer to pay is not, in legal strictness, a tender. The word imports not only a verbal offer, but a corresponding corporeal act. So payment is the act. So you can offer to pay verbally, and then you actually have to pay. As by producing and showing the amount, and this is strictly sustained by its etymology in the Latin tendere, or tendere, from which it is derived, signifying to stretch or hold out, to extend, implying that what is tendered is held out to the party for his acceptance, the party tendering thus representing, both by word and act, not only his willingness, but his readiness to do all in his power to satisfy the demand. As to the kind of money in which tender should be made. So if I'm going to buy a horse and I have money backed by gold, a symbol of something backed by gold, and someone can take it to the bank and get gold for it, then the tender is the paper. And I'm offering it as a sum of money to pay for something real, to pay for the horse. But I have to hold it out and give it to them, and they have to accept it and take it. To all things in his power to satisfy the demand as to the kind of money in which tender should be made, and generally what is a good tender. Okay, tender of issue, a form of words and a pleading by which a party offers to refer the question raised upon it to the appropriate mode of decision. The common tender of an issue of fact by a defendant is expressed by the words, "And of this he puts himself upon the country." Quote, "And of this he puts himself upon the country." That's interesting. Let's go back even further. We have 1740, Hodges, dang it, Student's Law Dictionary. Tender. In our law, now you see it's uppercase because that's the way they did it back in the old days, denotes as much as carefully to offer or circumspectly endeavor the performance of a thing. As to tender rent is to offer at the time and place. Now see, the Constitution is written much like this. Where and when it ought to be paid. I'm talking as far as the capitalization of the words. And a tender of rent on any part of the land occupied, or at any time of the last day of payment, will have the proviso or condition for that time, whether the landlord accepts of it or not. Yet, though the rent be duly tendered, the landlord may afterward bring action of debt, but he cannot thereon recover damages, for that the tenant's tender excuses the damages, but does not debar the landlord of his rent. But it is here to be observed that a tender of rent made in order to save the forfeiture must be of the whole rent due without any deduction on account of taxes, etc., unless it be particularly so agreed between the landlord and the tenant. For stoppage is no payment in law. It is held that where one pleads tender of a debt at the day, he need not plead semper paratus, that he was always ready, but uncor prist, still ready, and then bring the money into court. So just interesting stuff on tender. 1740. Let's see, I got a 1727 here. Cowell, a law dictionary. Tender may seem to come from the French tendre, tenor, delicatus, so like delicate, and used adjectively signifies the same with us in English, but in a legal sense, it denotes as much as carefully to offer, to circumspectly to endeavor the performance of anything belonging to us. As to tender rent is to offer it at the time and place where and when it ought to be paid. To tender his law of summons is to offer himself ready to make his law, whereby to prove that he was not summoned. So here it seems they're saying that tender means to offer, to, like the other dictionary definition said, to hold it out, to offer it. Okay, so to offer, carefully, as much as carefully to offer, endeavor, the performance of a thing, like to promise, to say, I promise I'll do this for that, thing belonging to us. I'll give you this for that. A contract. That's what a contract is. I give you this and you give me that, and I hold the paper out, the tender, delicate, like a piece of paper. I tender it to you. I hold it out to you, and you take it. So they hold out the paper money to us, and we take it. Okay, so tender and legal tender. Make of it what you will. Decide on your own if you like that or don't like that. My interpretation of the definitions. Or maybe you got another dictionary that you think has better, more accurate definitions. And if you do, post them in the comments. I'm just here to find truth, just like you. I've done some research and I'd like to share it with you. And I don't claim to be right about everything. I think I'm sort of leaning in truth direction. So like, share, and subscribe, and leave a comment, and I'll see you guys in the next video.